Hi, my name is Courtney Miner, and my mentor is Dr. Susan Castro. The title of my research is Hate Speech and Authority Figures, Harms and the Need for Regulation. The purpose of my research was to establish an argument in favor of legally regulating hate speech by workplace authority figures. Today I'll clarify the focus of the hate speech legislation, address the necessary justifications for limiting freedom of speech in the workplace, and finish by outlining the necessary conditions for effective workplace hate speech regulation. To begin with, we should have four basic considerations in mind. The First Amendment guarantees freedom of speech, meaning that the government is prohibited from imposing sanctions on private citizens for doing things such as criticizing the government. The Equal Protection Amendment prevents government from oppressing groups based on protected characteristics. Autonomy is a moral consideration with legal backing. The right to autonomy is expressed in U.S. law as the right to life, liberty, and the pursuit of happiness. And fourth, people disagree on what hate speech is. So what is hate speech? For the purpose of my argument, I will define hate speech as speech that is offensive, defamatory, discriminatory, or excludes members of society from being treated as equal to other members of that society. It should now be obvious how the other basic considerations apply. It's important to keep in mind that hate speech does not need to be delivered hatefully. It just needs to be the kind of speech that were the government to engage in it, it would be a violation of the Equal Protection Amendment. The question now is what really justifies restrictions on speech. Some speech is restricted because it compromises national security, some because it incites violence. Hate speech does not need to do either of these. So on what grounds should it carry legal sanction? The answer in this case is autonomy. Recall that autonomy includes the right to speak freely. However, autonomy is always restricted by its impact on others. Libel and slander are not merely prohibited because they are false speech, but primarily because they do harm. As we know from advertising, sheer repetition influences us, as does speech by authority figures. When we can't shut out an authority figure, their speech compromises our autonomy. The next issue for justification is understanding the harm associated with hate speech. The mental harm of hate speech is often thought to be insignificant because it is insufficient to meet the threshold for regulation or because emotion cannot be legally regulated. As I mentioned, hate speech does not need to be hateful, so instead, we should focus on the social harm caused by hate speech. Repeated denigration of a group has a profound psychological impact on us. When members of society are seen as unequal to other members of society, they begin to lose rights. Take, for example, the civil rights movement or the gay rights movement. Members of both movements had to combat the social harms of hate speech and fight to be seen as equal and deserving of the same rights. In addition to the Equal Protection Act, several other acts and precedents have shaped our right to freedom of speech. The Hatch Act of 1939 limits political activity in the workplace for government employees. In some cases, it extends outside of work-related activities. Twice the Hatch Act was challenged and then upheld by the Supreme Court. The justification for the Hatch Act is that it maintains order in the workplace by preventing undue influence from employee to employee and from employee to citizen. The Hatch Act is considered constitutional because the autonomy that we hold as a private citizen is not the same as the autonomy that we hold in the workplace. The best way to understand this is that you have a right to your speech, but you do not have a right to a job. This lack in workplace autonomy highlights the importance of addressing hate speech and a society's authority figures. Authority figures are those members of society who lead, who teach, and who are essentially representative of a country, anyone we might call a public servant. These jobs entail a fiduciary duty or a duty of trust to behave and treat those they are responsible for fairly and equally. When authority figures engage in hate speech, they are directly violating that responsibility. It is of the utmost importance that these members of society are subject to hate speech regulation. So why only authority figures? Authority figures have the biggest potential to commit the social harm associated with hate speech. They are entrusted and influential positions that empower them to be heard and believed. When they participate in hate speech, their words have the potential to permeate deeper into society than the average citizen. The average citizen is less likely to meet the threshold for significant harm. Because of their position, authority figures should be held to a higher standard. Take, for example, teachers. They have a duty to guide and educate any and all children who enter their classrooms. When they engage in hate speech, they send a message that says not all are welcome, which is a direct violation of their duty to act fairly. So what would that legislation look like? New legislation or precedent could be grounded in equal protection or the Hatch Act. As I mentioned, the Equal Protection Amendment protects classes of people from acts of oppression by the government. Agents of the government, like public school teachers and elected officials who represent the government, likewise have an ethical duty to refrain from harming or oppressing people through the power of their office. Since all of our lives are far more public than they were historically, authority figures may need to be held to a much higher standard than in the past. Currently, the Hatch Act only applies to political speech by those at work, on duty, or when they are representing their place of work. Political speech concerns institutions of power. Speech that subordinates a group is therefore a form of political speech. Given that authority figures are highly influential, an extension of the Hatch Act would be justified on the same grounds: to maintain order in society by preventing the social harm of hate speech, and to maintain trust between members of society and authority figures. Hate speech legislation such as this would not be a violation of the First Amendment so long as it only applies to those members of society that are considered authority figures or public servants. For such legislation to be effective, it must be consistently enforced. Given the importance of free speech rights of private citizens, we shouldn't necessarily be putting people in jail, but we can demand public apology or removal from the position. So in summary, the social harm of hate speech warrants regulation. That regulation should target authority figures because they have the biggest potential to commit the social harm, and when they engage in hate speech, they are violating their duties to those that they serve, and they are violating the Equal Protection Amendment. In addition to this, reasonable regulation ensures that the issue is being dealt with and can help lessen the social harm of hate speech. So the difficulty with the definition, a huge part of my research actually was trying to pin one down, because depending on how you view it, you may think it's as simple as just hateful speech, and it's not always that simple. I searched through numerous legal definitions from different countries, from different philosophers' work, and so this is kind of the one that I pinned down that, in my opinion, does the best at addressing what it is and what it does that's so problematic.
Thank you for that presentation. I think your argument is very elegantly constructed, and yeah, thank you. I wanted to ask if you had an opinion on whether, like, personal hate speech that doesn't come from a figure of authority could ever reach the point of becoming, like, legally defamatory or libelous or something like that.
So that's kind of outside the scope of what I've done, because my concern, so if you take libel and slander, I mean, those are types of hate speech, but libel and slander at this point only apply to one individual person. So in that respect, then yes, it already applies. But in this case, as for private citizens, that's just outside of what I was kind of looking at.